Welcome to this explainer. Today, we're going to do something a little bit radical. We are going to completely shatter the illusion of the law as this perfect, sterile machine. We so often imagine the legal system as this flawless algorithm, right? A system of pure, pristine logic existing in a vacuum. But today, we're pulling back the curtain. We're going to reveal the messy, profound, and beautifully human reality that actually runs the whole show. We are diving deep into legal realism, which was a massive, revolutionary movement that fundamentally changed how we understand justice itself.
Here's the roadmap for our explainer today. First, the revolt against formalism. Second, American pragmatism. Third, Scandinavian magic. And finally, Indian law in the trenches.
Act 1, the revolt against formalism.
Okay, so to truly understand this realist rebellion, we first have to wrap our heads around the prevailing myth they were fighting against, which is legal formalism. I want you to visualize a completely sterile black and white world. Picture blindfolded statues, perfect geometric shapes, and dusty, untouchable rulebooks. In the 19th century, orthodox thinkers like Christopher Columbus Langdale championed this idea of what they called mechanical jurisprudence. They honestly believed the law was a closed, scientific system of logical deductions. It was like a giant math equation. They treated the law as this brooding omnipresence in the sky, basically a set of pure, easily discoverable principles that were completely detached from the sweating, chaotic, vibrant reality of actual human life.
But here comes the rebellion, and this brilliantly illustrates the core premise of legal realism. It was a massive revolt, demanding that we bring the law down from the sky and plant it firmly back on Earth. Realism is all about studying what the law actually does in practice, not what it merely says on a piece of paper. It's the radical idea that you literally cannot understand the law just by reading textbooks. Instead, you have to look out the window at the crowded streets, listen to the ticking clocks, and pay attention to the highly flawed human beings who are actually making the decisions.
Act 2, American legal realism.
We're time traveling back to America in the 1920s and 30s. The Jazz Age dynamism is giving way to the extreme grit of the Great Depression, and the legal world is finally leaving behind those perfect geometric shapes for courtrooms filled with real, raw emotion. Let's pause right here to let this heavy-hitting statement from Oliver Wendell Holmes Jr. sink in. The life of the law has not been logic, it has been experience. This single, powerful sentence from his masterwork, The Common Law, essentially repudiates the entire formalist program. He argued that common law rules didn't just naturally evolve through pure logical derivation. No, they evolved through the felt necessities of the time, shifting public policy, and yes, even the everyday prejudices that judges share with their fellow human beings. It fundamentally shifts our entire focus from pure logic to actual human experience.
To really put this empirical approach to the test, Holmes introduces us to a fascinating thought experiment famously known as the bad man theory. Think of a shady character who literally cares absolutely nothing for morality, ethics, or some grand idea of natural law. He is not sitting around pondering whether his actions are right or wrong in some cosmic sense. He is only calculating the actual material consequences he's going to face from the courts if he acts a certain way. By looking at the law exclusively through the eyes of this bad man, Holmes basically strips away all that confusing moral language. He defines the law very simply as the prediction of what courts will actually do in fact.
Now enter another giant of American realism, Carl Llewellyn. He drew a razor-sharp contrast between what he called crumbling documentary paper rules and actual real rules. Now, Llewellyn wasn't saying rules don't exist at all, but he argued that the official formulations you find printed in big statutes are just paper rules. They might tell you where to look, sure, but they absolutely do not determine the final outcome. The real rules are the actual observable behavioral regularities of the judges. Think about it. The exact same paper rule can be applied in completely different ways, depending on the specific judge, the unique facts of the case, and the broader social context.
So you might be wondering, how did judges actually make these decisions if the paper rules aren't strictly binding them? Well, Llewellyn believed that expert common law judges possess what he called situation sense. It is an intuitive, highly trained capacity to perceive the specific type of situation presented by the facts and then craft a policy-sensitive decision that genuinely speaks to the needs of the community. He called this the grand style of judging. And the incredible thing is, this wasn't just some abstract academic theory. Llewellyn translated this into massive practical reform as the principal drafter of the Uniform Commercial Code in the U.S., literally building flexible standards like reasonableness directly into the very fabric of the law. Okay, let's get a little surreal for a second. What did the judge have for breakfast? This brings us to Jerome Frank, who hooked us with what is playfully referred to as digestive jurisprudence. Frank took realism and pushed it to its absolute psychological extreme. He brought up this wildly exaggerated but totally unforgettable metaphor that a judge's final ruling might ultimately depend on what they ate that morning. It is a hyperbolic way to state a deeply profound truth. If judicial decisions are genuinely shaped by physical conditions, personal biases, and hidden psychological states, then the absolute certainty of the law is really just a comforting myth.
Frank shatters this illusion of certainty completely by dividing the whole problem into two distinct parts. Holmes and Llewellyn, they were what he called rule skeptics, mostly focusing on how rules are interpreted, but Frank, he was a fact skeptic. He argued that the deepest, most foundational flaw isn't actually the rules themselves, but the immense psychological bias involved when completely fallible human beings try to determine the facts of a case at the trial level. Facts are not objective data points. They are messy, imperfect reconstructions told by forgetful witnesses and then filtered through the minds of biased juries and judges. He demanded that legal scholars stop obsessing over those neat, tidy appellate courts and get down into the messy trenches of the trial courts, because that is where real life actually happens.
Act 3. Scandinavian Legal Realism.
All right, let's pack our bags and head over to the cold, crisp Nordic landscapes because things are about to get really abstract. Imagine ancient shamans performing magic, juxtaposed right next to modern lawyers in a courtroom. The Swedish philosopher Axel Hagerström presented this incredibly radical idea that traditional legal concepts, things we talk about every day like rights, duties, and property, are essentially just modern magic. He was fiercely anti-metaphysical. His stance was simple. If you can't observe it or measure it empirically, it doesn't really exist. So the idea that signing a piece of paper magically creates this invisible, mystical entity called a binding obligation, he argued that's just the survival of pre-scientific mythological thinking hiding out in modern society. He wanted to tear all these invisible concepts completely down.
So if rights don't actually exist as physical objects in the world, what on earth are they? The crucial takeaway here is that the Scandinavians viewed the entire legal system as an elaborate linguistic illusion. Hagerström argued that rights are merely emotive attitudes and expressions of psychological power. The law doesn't operate through some perfect heavenly logic, it operates through deeply ingrained psychological conditioning. Basically, the state uses the heavy machinery of the law to condition its citizens to feel a very real sense of obligation. To make this abstract idea beautifully concrete, the Danish jurist Alf Ross gives us this brilliant analogy, likening the law to an incredibly tense game of chess. Think about it. If you watch two people playing chess, the rules of the game aren't physical objects sitting on the board. They only matter and they only truly exist because both players feel a very real, intense psychological pressure to obey them. Ross argued that legal validity works the exact same way. A law is valid not because it's handed down from the sky, but because we can accurately predict that judges feel psychologically bound to apply it. The invisible rules govern the behavior of the players, pure and simple. Act 4. Indian Legal Realism.
Now, let's ground all this high-level philosophy in reality by looking at the incredibly vibrant and complex landscape of post-independence India. This timeline tracks a massive paradigm shift in the halls of the Supreme Court of India. Think back to 1947, right after independence. The courts largely functioned as rigid, strict colonial umpires. But watch this evolution. Fast forward to 1973 with the landmark Case of Ananda Bharati case, where judges boldly created the basic structure doctrine. They stopped acting as mere umpires and became active creators of constitutional reality. Then moving into the 1980s, we hit the dynamic era of public interest litigation, or PIL, where the court actively steps in to shape social reality. This right here is realism in its purest, most practical form, acknowledging that formal, rigid legal rules often fail the marginalized, and so judges absolutely must step in to bridge that gap.
Indian judges truly embody the realist spirit because they are actively trying to achieve social justice right there in the trenches. They aggressively moved past what Llewellyn would have called mere paper justice to demand true, substantive equality. They took Article 21 of the Constitution, the right to life, and expansively interpreted it to include the right to dignity, a clean environment, and education. And it goes even deeper. Echoing Jerome Frank's intense fact skepticism, the modern Indian Supreme Court frequently appoints its own independent fact-finding committees in highly sensitive, complex cases. We've seen this in recent years with the Pegasus snooping allegations and the Hathras case. They recognize that the official facts presented neatly on paper are often unreliable constructs, and that achieving true justice requires digging down and getting independent verification.
The human behind the robe. As we wrap up this explainer, I want you to picture a judge, just about to put on their black robe. As they sit down at the bench, think about their eyes. They aren't robots. They bring their own subjective human calculation to the table every single time. Legal realism forever changed our view of the world by utterly destroying the myth of the flawless machine. It exposed the massive gap between shiny legal doctrine and actual judicial reality. It challenged the magic words, it burned the paper rules, and it leaves us with this incredibly provocative realization. The law is absolutely not a brooding omnipresence in the sky. It is, and it always will be, a beautifully, messily, and profoundly human enterprise. So can we ever truly separate the law from the humans who create it? Probably not. Thank you so much for joining me on this explainer. Keep questioning the rules and always keep looking for the reality behind the robe.